Welcome to the Small Business Contracts Coach.
Welcome to the Small Business Contracts Coach with attorney Darryl Shaper of the fixed fee law firm PLLC. Darryl helps Texas entrepreneurs build smart, predictable legal systems that keep their businesses running smooth. I'm Leanne Lyon, and today we are discussing buying and selling a small business in Texas. Darryl will explain what buyers and sellers should understand when a small business changes hands from early negotiations through closing. Good morning, Darryl.
Hey, good morning. Great to see you.
Darryl, when somebody is thinking about buying or selling a small business, how do brokers typically fit into the process, and what should people clarify before relying on one?
Well, I hate to be a negative to start off the podcast, but I don't enjoy working with brokers. When I do a lot of buying and selling of businesses, I probably have done 20 to 50 each of the last few years, sales or purchases of businesses. When there's a broker involved, the broker often has a form of the asset purchase agreement or purchase and sale agreement for the company that they propose to one side or the other to use. Those forms are almost uniformly terrible. And additionally, they're incredibly focused on protecting the broker and their fee instead of really caring about the transaction as much as they should. So please don't use the broker's form as warning number one. Get an actual lawyer involved and get them in. The other thing I'd say is I've had a number of clients use brokers to try to find businesses, et cetera. I'm not aware of people having super good luck with that. So in general, selling or buying your business without a broker can be a good idea. And it's not like a real estate transaction where you have to have a broker involved. So to some extent, I recommend not using brokers unless you're unable to find or sell your business.
Well, before negotiations get too far, valuation becomes a big focus. So, how should buyers and sellers think about value, especially when comparing historical financials with pro forma projections?
It's interesting. It is a super important element of the deal, but it's not a legal issue so much, right? So the valuation of the business is often determined between the business people without the lawyers being involved. I will say, and this may be very helpful to people, and some people won't give you these rules of thumb. So a very basic rule of thumb for thinking about selling a private or smaller company is something like 5 times your EBITDA, which is earnings before interest, tax, and depreciation and amortization. So 5 to 10 for a multiple of EBITDA can be pretty good. For services businesses, it depends on how fast your business is growing. So all kinds of stuff. You can look at what the public company PE ratios are. That's comparable. And those tend to be much higher than a private company valuation. So once you're out on the public markets, you get a better PE multiple. So you should expect to be less than what you would get going public. And then other businesses that are highly dependent on the person involved have much lower valuations. So, for example, law firms very frequently sell for 1 times their revenue, right at their revenue. Even if their margins are outstanding, it's just a multiple of 1 times revenue. So that's highly variable based on the business and is a negotiated issue between the buyer and the seller.
Well, I know whether or not a broker is used, a deal often starts with a letter of intent. What does an LOI usually cover, and how does it shape the timing and sequence of the rest of the transaction?
So great. I'm a big fan of LOIs. They are very helpful at speeding up the negotiation of the transaction. They can be completely non-binding, but people tend to act in good faith and honor what they've put into the LOI. So they're typically completely non-binding, yet people take them quite seriously as they go forward in the deal. So caveat number one here is please, please, please get a lawyer or your lawyer for the transaction involved at the LOI stage. Because even though they're non-binding, renegotiating some key element that's in the LOI after the fact, when you get your lawyer involved who says, whoa, 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 you've done this in the LOI, it becomes much, much more difficult. So it's extremely important to involve a lawyer in the LOI. There can be all kinds of things, but in general, it's going to be, hey, here's some kind of valuation that we think is reasonable. Here are how long we think things are going to take, and we're committing to some levels of timeline. Frequently, the buyer asks for exclusivity to be the only person negotiating with the seller for some period of time in that LOI. That part might actually be binding depending upon how it's written, but it's certainly, again, treated with respect in general by people when they agree to an LOI. There can be a wide variation in what's included in an LOI, which again is a good reason to get your lawyer involved early. And I think it's generally a good idea to do an LOI early on.
Well, once everybody moves on from the LOI to the actual purchase agreement, what are the key terms that really determine how the deal works in practice?
Well, the key provisions in my view that you need to think about as a buyer or a seller are liability. How much liability do I continue to have ongoing if I've sold the business, or how much liability does the seller owe me? So that's number one. Indemnification. So do they cover me as the buyer? Let's just again stay on the buyer side. Does the seller, if some lawsuit from a third party comes up, indemnification means you cover me for that lawsuit during the time that you own, related to the time that you own the business. That's fairly typical and very important. Those are key legal provisions. Then there's a section where the seller and the buyer, but much more important from the seller, makes a whole series of representations and warranties, things that they say are true. There's no litigation. I own the company. I own it 100% myself. I have the right to sell it. There's no debt. These representations and warranties are extraordinarily important, and they're what expose the seller to potential liability. How long do those reps and warranties survive becomes very important. So there's a whole array of things that are highly important in that document. But one thing that we haven't talked about, and that I just want to pause briefly, that's one of the most important early decisions at the point of the LOI, potentially, or certainly going to come clear when you get to the purchase and sale agreement, is, are you selling the company, the legal entity, if it's an LLC or a corporation? Are you selling the legal entity to the buyer, or are you only selling the assets to the buyer? I highly, highly recommend, as a buyer, and frankly, even to some extent as a seller, an asset purchase transaction tends to be much safer for you as a buyer. Because if there are undisclosed liabilities or some shareholder hidden away, you didn't buy the entity, you just bought the assets in the ongoing business, and that tends to be much safer. The only exception to that might be if it's a corporation. There's a law that changed recently under the new administration called QSBS, Qualified Small Business Exception, that can, if you own a C corporation for 3 years or more, you get significant reductions in your tax liability. And I'm not a CPA and I don't play one on TV, but if you're buying a C Corp, it might be interesting to buy that entity and then potentially continue to hold it for a period of time. And maybe you can qualify for QSBS, capital gains exemptions, which can be really significant. It could be up to $10 million of capital gains that you can avoid taxes completely on.
Wow. Speaking of money, earnest money and earnouts both come up a lot in small business sales. How do these two concepts differ? And what should each party understand about how they reduce risk or shift it?
Interesting. So these are totally different concepts. So let's start with earnest money. Earnest money is an amount that you pay down as the buyer to the seller or potentially into an escrow company to show that you're serious about the deal. So I might put $10,000 in earnest money down. And then if I don't go through with the deal for some reason, I might lose my earnest money. So it means I'm serious. I really might want to buy it. So it's a signal from the buyer to the seller that I'm serious about this deal. I'm willing to put money down. That's the earnest money concept. Relatively simple, actually not that frequent in small business transactions because finding an escrow agent is kind of a pain. And most buyers don't want to put money at risk when they're not sure they're going to do the deal. So they're not that frequent. Earnouts are much more frequent. Earnout is a totally different concept. Earnout is I'm buying a business. The business does $2 million a year in revenue each of the last 10 years. It hasn't grown, but it does $2 million a year of revenue and it does $200,000 a year of profit. When I'm buying that business, I'm expecting to make $200,000 a year of profit off the business. My earnout might say, if in year 1, 2, and 3, it doesn't do $200,000 in profit and doesn't do $2 million in revenue, seller only earns their money if it continues at the pace that we expect it to continue. So let's say I pay half the money up front. I'm buying this business for $1 million, 5 times EBITDA, right? 5 times profit. I'm buying it for $1 million. I'm going to pay them $600,000 up front on the day of closing, and they're going to earn out the last $400,000 based on the profitability over the next 3 or 4 years. So if I make $200,000 in year 1, I'll pay you the next $100,000. If I make it again the next year, I'll pay you another $100,000. So that would be an earnout. And that shifts significant risk away from the buyer because now if they don't get what they expected they were getting, they don't pay as much for the business.
Interesting. Well, due diligence can be the longest part of the deal. What kinds of information tend to matter most during this stage? And what do people sometimes overlook before moving towards closing?
Yeah. So number one is the financials are incredibly important, right? So understanding the tax documents and the tax filings for the business, the financials and whatever extent they're audited or done by a CPA. Frequently in small businesses, they're not as carefully done. So you want to study those and get people involved. But there are also sort of legal due diligence issues. Like I had a deal at the end of the year that was really interesting where there were multiple shareholders involved and we were selling a business for $1 million again. And I went and asked the shareholders for a consent to sell. So sometimes you don't need their consent, but in this case, we needed their consent. And some of the shareholders did not consent to the sale. And so by asking during the due diligence period for a consent, we exposed that maybe we had some unhappy shareholders that didn't want to sell. And so that led us to slow down a little bit and eventually work with the shareholders to get approval, and hopefully the deal will still close. But understanding who owns it, whether they've consented, what rights do they have, that's the legal due diligence that's typically involved. So reviewing the bylaws or the operating agreement, seeing if there are drag along, tag along rights, which are important shareholder provisions that I won't go into, but potentially allow you to pull shareholders who might object. In this case that I was talking about, there was no drag along, so we couldn't force these shareholders to sell.
Got it. Well, financing can take many forms in these transactions as well, from SBA loans to equity contributions to seller financing. What tends to influence which structure makes the most sense for a particular deal?
Yeah, great question. Number one, SBA loans are amazing. If you can get an SBA loan, they tend to be a good deal for a small business owner, but they're complicated and they take a lot of time and they add cost to your deal because the SBA has a whole array of requirements. So if you qualify and can get an SBA loan, that can be a great way to go. On the other hand, seller financing is preferred. If you can get the seller to loan you a portion of the money or to take some form of an earnout, that's much simpler and faster than an SBA loan. So if you can get a seller who's willing to do some form of seller financing, that's absolutely fantastic. And then, almost every deal is different, right? Are there other investors coming in, putting money into the new entity that's going to buy the assets? It gets complicated and each deal is bespoke. And this is where you need a experienced M&A lawyer to come in and help you with your small business transaction. Back to that other transaction, interestingly too, big firm, this company went to a big firm who wanted to charge them over $100,000 to do this $1 million transaction. And with my firm, we were able to do that for a $5,000 fixed fee. And it was a fairly complicated deal. My fees can be lower than that for M&A work. So it's interesting, huge variation in how the deal works. You definitely want somebody who's experienced, but be careful. The big firms will charge you a heck of a lot of money very quickly.
As we wrap up here today, what would you recommend if a business owner is considering selling soon or a buyer is out there looking? What really should be their first step, maybe before they even connect?
I do think if you can get a little bit of time with me or some other relatively experienced M&A lawyer to get some perspective, that would be helpful. You should talk to friends and family who've sold a business or other companies in your industry to understand what are the valuation metrics that apply in your industry, because they tend to be pretty standard by industry. Like I talked about, law firms, if you look at software as a service, they do 20 times annual recurring revenue as the valuation, nothing about profitability, because they tend to be high growth, high margin businesses. So talking to experienced people who've been through it before is what I'd recommend.
Excellent. Well, that concludes our time together today. Thank you for listening to the Small Business Contracts Coach. And if you'd like to simplify your contracts and protect your business with fixed fee legal help, visit fixedfeelawfirm.com and be sure to like, subscribe, and share this episode with a business owner who might need it. Thank you, Darryl.
Thanks, Leanne.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.